and welcome to this Garden Court webinar on coercive control. And thank you very much, everybody, for attending. I just need to deal with some housekeeping matters before we get any further on. You've been placed on mute, and please, can you pose any questions that you have in the question and answer window? And if you want those questions directed at a particular speaker, please say so. The chat function is enabled for any other comments, queries and/or feedback, but please don't pose any questions in the chat function. The resources will be circulated to registered delegates after the webinar. The webinar is being recorded, and what that means is the audio and video of the panelists and anyone who speaks, if they are unmuted, will be recorded. And this webinar may be shared on our marketing channels, including our website and social media. And please refer to the instructions in the chat window if you are experiencing technical problems. Coercive and controlling behaviour is a very topical issue, both in the criminal court and the family court. And today we have brought together practitioners from both jurisdictions from Garden Court to speak. And we are also privileged to have as our key speaker, Sally Challen's son, David Challen. Rachel and I will be co-chairing. I'm Maggie Jones, and I'm a very long-standing family practitioner at Garden Court. Rachel, in contrast, is an up-and-coming young family barrister who became a tenant in chambers last week, having done a pupillage with us. And it has to be said, having just done a pupillage is very useful in many ways, because she's had recent experience of both the immigration and the criminal courts. And she also shadowed Claire Wade in the Sally Challen case. And I think that she has both an intellectual and a very practical approach and outlook to her practice. Rachel and I will be co-chairing, and she will also be speaking, and I will be chipping in with some bits and pieces too. So now I am going to hand over to Rachel in the first instance for her to look at the issue of why coercive control is so topical at the moment. Over to you, Rachel.
Oh, thank you, Maggie. So coercive control is a term that has definitely really increased in usage over the past 5 years. And I wanted to think about why that's happened. And looking back to 5 years ago, the Serious Crime Act actually created a new offence, which is controlling or coercive behaviour in intimate or familial relationships. So what that means is that now people can be prosecuted in the criminal courts for the offence of coercive control. While this is an offence that is quite a new offence, the numbers of people prosecuted have been going up in recent years, and that may be because coercive control has been there's an increasing awareness of coercive control in the general public. Some reasons for that might be because it's something that's increasingly been featured in popular culture. So, for example, in 2016, there was a storyline in The Archers involving Helen and Rob, which got a lot of media attention. And more recently, during the lockdown, the story of Yasmin in Coronation Street has also been a topic of conversation. Of course, we also will remember the Court of Appeal case of Sally Challen in 2019, when Claire Wade, who is going to be speaking later, represented Sally Challen, and her murder conviction was overturned when new evidence was looked at by the court, looking at the impact of coercive control on her state of mind. Of course, we're also going to be hearing from David Challen, Sally's son, who's been a campaigner to raise awareness of the issues surrounding coercive control and domestic abuse more generally. In addition, we've also got the Domestic Abuse Bill, which is currently going through Parliament, and that is going to create a new statutory definition of domestic abuse, which will include controlling or coercive behaviour, and will be a statutory definition to be used throughout different jurisdictions, and will mean that there's consistency, in different courts, rather than different jurisdictions. So the family and the criminal courts will be using the same definition. And of course, coercive control is something that is coming up a lot for family practitioners, and in many cases, coercive control will feature. And so I'm just going to hand back to Maggie, who can tell us a bit about a recent case she was involved in, which is the case of P, which has just been in the Court of Appeal.
Thank you, Rachel. I'm going to talk briefly about a case that it's a case of R and P, and it was in the Court of Appeal in August. And it was an appeal against a case management decision to exclude evidence in family proceedings. The proceedings were a father's application for contact with children, and the mother opposed contact on the basis that the father had subjected to her to extreme coercive and controlling behaviour and to sexual abuse. And in support of her case, she wanted to rely on evidence of what she argued was strikingly similar coercive and controlling behaviour by the father towards another woman with whom he began a relationship shortly after her relationship with him ended. Now, I came in to this case at the Court of Appeal stage, and Michelle Lubell from Duncan Lewis, who I think is with us this evening, had worked on it for 3 years. It is still ongoing. And I'm going to go through the facts because I think it is so striking, this particular case. It concerned a young woman who met her partner at university when she was 18. Within less than 2 months, she was pregnant, losing contact with her friends, and there were difficulties in her relationship with her family. She then withdrew from her university course. She became effectively homeless. She became engaged to this man, and she stopped attending any antenatal appointments. She and this man started moving around shared accommodation, and her parents did not know where she was. After the baby was born, her parents located her, but she and her partner continued to move around shared accommodation, both in the town where they'd been at university there in London for almost another 3 years before she eventually left him and he started proceedings. And it was in the Court of Appeal judgment, Lord Justice Jackson lists the behaviours of this particular guy. He insisted on her abandoning her studies. He misrepresented his name, occupation and financial position to her parents. He sent messages to her family purporting to be from her. He isolated and alienated her from hitherto close family and friends. He made baseless allegations to public bodies, including to the police, against her family. He required her to move constantly to isolate her and to avoid them being found by family and public bodies, to the extent that her parents hired a private detective to locate her and their grandchild. So that was the position with my client, who eventually left him. And very shortly afterwards, he started these proceedings. And within those proceedings, and via a link between police forces, it was learnt, because I wasn't in the case at that time, that this bloke had linked up with another woman about a month after he left our clients. And it was a woman in her 40s, a professional woman, and that, in fact, that again, Lord Justice Jackson says in the judgment that she left her job as a school teacher within months of meeting him. She became estranged from her family and friends, and she lost her children. And again, there were similar facts about making accusations to public bodies, etc. So there were 2 cases with very, very similar facts. Now, it was extremely unfortunate that this case as well we had huge delays. It started in September 2017. There were, I think, 15 hearings in front of 12 different justices. And there was inconsistent or non-existent legal representation from father. It was listed for a fact-finding on 4 different occasions. And there were all kinds of procedural muddles about it. But in June, it came at the pre-trial review before the 4th fact-finding hearing that had been listed, before a judge who'd never heard it before. And that judge said that any documents in respect of the other proceedings, which were on foot in respect of the other woman's children, should actually go out of the bundle. And it was that decision that was appealed and successfully appealed. And the Court of Appeal said, yes, this was similar fact evidence and it should go in. So the appeal succeeded. And that within his judgment, Lord Peter Jackson noted not just the chaos that had been in the case, but also the limitations of what we in the family division call Scott schedules, in terms of actually how you put together evidence in these cases, because Scott schedules are documents that put together, quite often 5 particular incidents, and that actually doesn't make any sense when there's been a course of conduct, a pattern of acts in these kind of cases. And just to keep you up to date on that one, it was remitted by the Court of Appeal back to the High Court. And we were there last week and the week before. And I can tell you it was the most extraordinary hearing in front of Mr. Justice Hayden, who is going to have a lot to say about cases of coercive and controlling behaviour, and about the use of Scott schedules, and about police inquiries and actions or non-actions, and about delays and lack of judicial continuity. So that we await the judgment, but I think that is going to come in the next couple of weeks. So that is the case of R&P in the family division. Right, I'm going to hand back now to Rachel and to Claire Wade, who I'm sure that many of you will know Claire very well. I've known Claire for a lot of years now, but Claire is a highly experienced, successful and committed criminal QC, and has been instructed in numbers of high-profile appeals in the last few years. She is a specialist on women and the criminal justice system. She represented Sally Challen in her out-of-time appeal against her conviction for the murder of her husband. And that case, as most of you will know, was groundbreaking, and the first time the Court of Appeal had considered coercive control in the context of partial defences to murder. And the case changed the way in which domestic abuse is viewed in the criminal justice system, and was widely reported. And the appellate process was the subject of a 90-minute BBC Two documentary. So I hand back to Rachel and to Claire. Thank you.
Thanks, Maggie. So I'm just going to talk a little bit about, what is coercive control, and looking at the legal definitions of coercive control. So in the family courts, Practice Direction 12J is guidance which is applicable to all cases in the family courts which involve domestic abuse. And in Practice Direction 12J, domestic abuse is defined broadly as including any instant or pattern of instance of controlling, coercive or threatening behaviour, violence or abuse between those aged 16 or over who are or have been intimate partners or family members, regardless of gender or sexuality. This can encompass, but is not limited to, psychological, physical, sexual, financial or emotional abuse. And then within Practice Direction 12J, coercive behaviour is defined further as an act or a pattern of acts of assault, threats, humiliation and intimidation or other abuse that is used to harm, punish or frighten the victim. Controlling behaviour is also defined in Practice Direction 12J, and it's defined as an act or pattern of acts designed to make a person subordinate and or dependent by isolating them from sources of support, exploiting their resources and capacities for personal gain, depriving them of the means needed for independence, resistance and escape, and regulating their everyday behaviour. And interestingly, this practice direction, which was revised in 2017, actually uses the same definitions of domestic abuse and coercive control that are currently used in government guidance for prosecutors, so the CPS guidance. But as mentioned before, the domestic abuse bill that's currently going through Parliament will ensure that there is one statutory definition of coercive control to be used in, and domestic abuse to be used in all contexts. So the question then is, where did coercive control come from as a concept? Of course, these are the legal definitions, but actually it's something that came from the academic sphere. And in particular, Dr. Evan Stark is a social worker based in the States, and he is the person who actually coined the term coercive control. And the term is used to describe a course of oppressive behaviour grounded in gender-based privilege. So for Stark, coercive control was very much something that happens to women and is perpetrated by men. And what's important in the way that Stark looks at coercive control is that he had an understanding that domestic violence isn't just about individual acts of physical or emotional abuse, but actually domestic violence is something that pervades a relationship. And in order for physical or emotional abuse to take place, there will be a context in the relationship of other abusive behaviours. So examples include isolating someone from their friends and family, monitoring their time or movements, controlling their everyday life, putting that person down, or controlling money or other forms of financial abuse. And Stark thinks of coercive control as a pattern of behaviour that can actually trap victims in an abusive relationship. So for him, coercive control is something where the victim, it's something that stops the victim from being able to seek help and leaves them powerless. So I'm going to just ask Claire Way to speak a little bit more about Stark's theory of coercive control. It's something she knows a lot about. And actually, Evan Stark was someone who gave evidence in the Sally Challen appeal. So I'll just hand over to Claire now.
Thank you, Rachel. Well, the coercive control theory expounds the way in which behaviours of violence, intimidation, isolation and control are used to abuse usually women in domestic relationships. In doing so, it shifts the emphasis in cases of domestic abuse away from a calculus of individual physical harms to a pattern of control, which entraps the victim by threatening her physical and psychological integrity. Her personhood, her agency, her autonomy is what is at risk, and her sense of self is distorted the more she is subjected to the strategy of coercive control. The emphasis then is on the pattern of control, and the abuse focuses attention on the victim's constrained choices for survival. Evan Stark has been using his coercive control framework since 1995, but it still appears new. And in many senses, I suppose that is because, as Stark says, coercive control has often been almost normalised. The reason being that abuse tends to take hold by stealth. The fundamental rights, and it's a rights-based theory, the fundamental rights that coercive control violates are taken for granted by and large. and they are completely entwined in female behaviours and female gender roles. So in Stark's word, when those rights are abridged, that abridgment passes without notice. And that's really because the infringements into the way women do, say, housework, the way they dress, the way they look after children, the way they manage money, the way they socialise, communicate with family and friends, they're all potential harms caused by coercive control, which have no counterpart at all in public life. And so they historically, they've been harms that the law doesn't recognise. And cases which involve a matrix or a background of domestic abuse, the sort of cases that I've been involved in over the years, until recently were determined without any reference whatsoever to the theory of coercive control. Sections 52 to 55 of the Coroners and Justice Act 2009, which is an act, the impetus for that act was to provide better access to the partial defences to murder to victims of domestic violence. That was enacted without any reference at all to coercive control. The theory of coercive control played no part in the policy decisions undermining the Act, and a search of Hansard reveals that coercive control was not referred to at the committee stage of the bill. So it wasn't until, in fact, 2012, I think it's 2012, we find the first reference to coercive control in Hansard. So as a framework for understanding domestic abuse, it's certainly new to criminal law. And within the criminal, within traditional criminal jurisprudence, the understanding of domestic abuse has tended to focus on the impact of violence on the victim. So formulations such as battered women syndrome, post-traumatic stress disorder, have placed emphasis on individual acts of abuse, individual acts of physical violence usually, and the consequent psychological state of the victim is where the focus lies. And once the focus is on the victim, it's not on the dynamic which has caused that psychological state. This emphasis is undermined. It's traditionally completely undermined the worst facets of domestic abuse, which are subjugation and systemic coercion and degradation and control. Rachel mentioned Section 76 of the Serious Crime Act, and I'm sure that everybody is now familiar with that. It makes coercive control, as she said, a criminal offence. And it's truly radical because what it does is it prescribes a repeated course of controlling and coercive behaviour that has a serious effect on the victim. And it has a serious effect if it causes the victim to fear violence or causes serious alarm or distress, which has a substantial effect on her day-to-day activities. So it reflects a modern understanding of domestic abuse. And as a matter of substantive criminal law, it's radical because it defines an actus reus of coercion, which can consist of a series of acts which on their own and viewed individually are non-criminal. And of course that act, Section 76 of the Serious Crime Act, draws directly on the work of Evan Stark. So he would expound coercive control as a dynamic where abusers deploy a broad range of non-consensual, non-reciprocal tactics over an extended period to subjugate or dominate a partner rather than merely to hurt her physically. And compliance, of course, is achieved by making victims afraid and denying basic rights or resources and liberties without which they're unable to escape. They are, in other words, entrapped. They're unable to resist or escape. And major elements of coercive control are physical and or sexual violence and coercion. Threats such as stalking, monitoring movement, intimidation in the form of isolation and degradation, But for Stark, the most commonly cited forms of control tend to be exploitation. In other words, treating a partner like a servant, deprivation, for example, depriving a partner of money, and of course the micro-regulation of daily activities and dictating how a woman should spend her time. So it's important to recognise, and the law now does, I think, recognise that it's not a psychological condition. It's not a diagnosis, but it's a widespread behavioural strategy that contains predictable elements and follows typical patterns. It's deployed to garner predictable consequences. It has predictable consequences, and the most widely recognised consequences are, of course, fear and dependence and a level of constraint on a victim's choices. It tends usually to involve a planned and strategic course of conduct, which is carried out over time and designed, as I've said, to exact personal gain and privilege. And compliance with coercive control is underpinned by the or else proviso. According to Stark, it's only in 25% of cases that violence is actually used. Most subordination is achieved either with little violence or long after violence has ended. Importantly, in many cases of coercive control, the ultimate risk is one of suicide or homicide. And it's a function of a victim's level of entrapment that she's deprived, as I've said, of any non-violent means to resist or refuse or to escape the demands of the perpetrator. According to Stark, the average length of time for a controlling coercive relationship tends to be 7 years. But of course, the longer the duration of the relationship, the more likely homicide is to result. And that can be homicide in a form of a victim killing her abuser, or more likely than not, abusers killing their victims.
Thanks so much, Claire. And I'm now going to hand over to Stella Harris and Claire Wade, who are going to talk about evidential issues when trying to prove coercive control. Claire Wade has obviously already been introduced by Maggie, but to introduce Stella, I'd just like to say that she's also a criminal barrister at Garden Court, and she also routinely acts for women accused of murder and other serious violence, both at trial and on appeal. Stella is especially interested in supporting women to secure their full participation in proceedings and to ensure that the context of their behaviour is properly understood by obtaining supporting evidence and using the latest psychological and psychiatric evidence. So over to you, Stella and Claire.
I'll start, as I've just finished, I'll start with my own experiences are in defending murder cases or mounting appeals of women who have been convicted of killing their abusive partners, male partners. And the starting point, I think, to recognise is that to accept that the offence of coercive control does not of itself provide any form of a defence. All it does is incorporate in law via Section 76 an understanding of the dynamic which underpins domestic abuse. It's been used within the context of the partial offences, as has been said, the partial defences to murder, as has been said, with Sally Challen's case being the first case where coercive control was accepted by the Court of Appeal Criminal Division. It was accepted that it could factor into both the partial defences of provocation, as it was at the time, and diminished responsibility. But as was said at the time by Lady Justice Hallett, it's important to remember that coercive control as such is not a defence to murder. The only partial defences open to the appellant were provocation and diminished responsibility, and it's only relevant in the context of those two defences. It follows, coercive control having been relevant to the partial defence of provocation, that it will also be relevant to the partial defence of loss of control provided by sections 54 to 55 of the Coroners and Justice Act 2009. The defence is, of course, triggered by things done or said, which A, constitute circumstances of an extremely grave character, and B, cause a defendant to have a justifiable sense of being seriously wronged, as well as or instead of a fear of serious violence. Coercive control is often said to be a bespoke form of abuse, where a perpetrator will identify and exploit features or factors which are peculiar to the victim. It's a form of abuse in a way that's tailor-made, and it's tailor-made to target any one victim's specific vulnerabilities. Targeting the psychology of the victim can have the effect of an abuser, of course, being able to exert control even when he is not in the victim's presence. In the partial defence of loss of control, the defendant's personal characteristics, often vulnerabilities such as medical or psychiatric conditions, are not relevant to the third limb of the partial defence, namely whether a person of the defendant's sex and age with a normal degree of tolerance and self-restraint in the circumstances of that defendant might have reacted in the same or similar way to the defendant. Personal characteristics are relevant to the second limb of the partial defence, namely the qualifying trigger, and they will go to the gravity of that trigger. And given that coercive control is, as I've said, often contextual in terms of a perpetrator attacking the particular vulnerabilities of a victim, it's a dynamic which is consistent with the partial defence. Factors which are of particular or potential relevance when looking at these cases tend to be, for example, incidents of sexual violence or exploitation, which might necessarily have no temporal connection at all with the offence with which the court is concerned. They may nevertheless be highly relevant. It's important to bear in mind that coercive control is designed to achieve compliance. It's designed to suppress conflict. And so an absence of incident-based violence is potentially significant. It doesn't mean that a victim hasn't been provoked. It doesn't mean necessarily that there is no trigger. As with provocation, the trigger can be cumulative, and it will be necessary to disaggregate the various strands of what used to be called provocative conduct, which is now conduct that goes to the trigger. And so the importance of taking a full history from the defendant can't be overstated. Ultimately, each case is different, and the coercive control theory is heuristic. It provides the basic tool for unlocking any one particular factual matrix. So, for example, in Sally's case, one of the things, and Harriet, my instructing solicitor, was working on that case for many years before it came to court, and I certainly was working on it from 2015. But one of the cases that struck us initially, one of the factors that struck us initially was the fact that Sally seemed to have no identity. She felt she had no identity of her own. It seemed as if she couldn't conceive of life without Richard, her deceased husband. And that was really the starting point for looking at the control that she had been able to speak of from the day that she had been arrested. It became a means of unlocking the case. And what coercive control can do is provide, in any one case, I suppose, an evidential context. Once the theory is applied, it can change the narrative of a trial. So again, in Sally's case, the narrative of the trial at first instance was very much the narrative of the typical, a stereotypical jealous woman. But in fact, by using the theory of control, we were able to show that her actions, the actions that were said to be associated with jealousy, such as constantly checking and looking for proof of things like extramarital affairs, were capable of being seen as being the result of gaslighting, a particular form of emotional and psychological abuse, where the victim is effectively told that she doesn't know what she does know. So what she knows to be wrong, she is constantly told that it isn't wrong. And it has the consequence in worst case scenarios of a victim believing that she's going mad. On the other hand, in cases of diminished responsibility, it's important, I think, to look at the interface between any recognised medical condition, which is necessary to be able to mount the defence. It's one of the four limbs, four criteria for the defence, from which a defendant is suffering, and coercive control. So, for example, it may be that a defendant is suffering from post-traumatic stress disorder as a result of violence within the deployment of coercive control. It may be, as in Sally's case, that there is a diagnosis of personality disorder, which makes a victim particularly susceptible to coercive control because it makes them particularly dependent. In that case, in Sally's case, there was psychiatric evidence of a mood disorder and probably bipolar disorder. And the most serious aspects, we were able to argue, had been masked, as it were, by the coercive control. It didn't become really apparent, until she was out with the situation of coercive control, which, of course, she had been in for many, many years. So where psychiatric evidence is necessary, it's obviously important to instruct a psychiatrist who understands coercive control and the way it underpins domestic violence. In Sally's case, the Court of Appeal held that they didn't need to admit the evidence of Evan Stark under Section 23 of the Criminal Appeal Act, because there was a psychiatrist who was able to give fresh evidence of various psychiatric conditions, the conditions I've mentioned, and who understood, importantly, coercive control. But it's important, I think, in looking at evidence gathering for these cases in the future, to consider the possibility of adducing expert evidence, which is not psychiatric evidence, it's not psychological evidence. As long as that evidence doesn't touch on the particular facts of the case, there's no reason why it shouldn't be adduced. And it's certainly possible. It's certainly possible in other jurisdictions. It was recommended by the New Zealand Law Commission, for example, that refuge workers and those who are well versed in the dynamics of domestic violence could potentially give expert evidence. And it's certainly been used in Queensland, in Australia. So I think the case is called GAD, but it certainly happened at first instance. So that is one of the main things I think I would like to see change. Anyway, on that note, I'm going to hand over to Stella, who's going to tell us a bit more about the sort of evidence that we I think should be looking for when we're doing cases involving women who've been subjected to coercive control.
Thank you, Claire. I'm a criminal defence practitioner, so I don't represent the prosecution, but we very much welcome the inroads that have been made by the Section 76 offence, I should say. And I've got a handout here, which you will all get a copy of, but just really as a headline, understanding about this topic, it is very significant, and it helps women who are charged with serious violence and who are part of wider proceedings, if we all understand what this really means. So already if Amy, if you could turn to the slide at 3, we've got there the definition of abuse, which we've already had a look at, and some supplemental guidance there. The statutory definition that will be coming out of the domestic abuse bill, and they have the government have received submissions from the Prison Reform Trust, the Centre for Women's Justice and Women's Aid, all of which have taken the discussion forward about this statutory definition, which will be very welcome and which we anticipate will be underpinned by guidance and training. So a big step forward, as I said before, was the Section 76 offence. And the criteria for that is a little bit set out there. It must be repeated, it must have a serious effect, and it is necessary to prove intent to control or coerce. And if we just go over to the next slide, please. There are some examples of a substantial adverse effect there. And again, the domestic abuse bill will include people 16 and over. So we've got attendance at school and the like there. And those are features that if you're defending someone who has this pattern of behaviour in their background, that you might want to look at putting together a case, which is in the later slides. In criminal law, we don't have schedules, and indeed, I think we find it quite difficult to put together cases where there is a convoluted, as the courts would consider, or a lengthy background. And we're much more used to dealing with single incidences. So ensuring that a narrative and the complete account comes over in court is something that's really a challenge in the criminal world. If we just turn over for a moment, please, to the next slide, we've got some further examples of behaviour. And again, this is part of the Home Office's statutory guidance when the 2016 Act came out. And what we can see is some of the patterns there that you will all be familiar with. There are very many, and as Claire has said, very particular to the individual person. And if we go over to the next slide, there are even more examples there. When looking after young people, looking and acting for young people, for example, preventing them to accessing education, disclosure of sexual orientation, and like. And if we go over to the next slide, please, Amy. Additional factors that Claire and I would draw to your attention is what's already been explained as that framework of entrapment, which is designed to achieve compliance. So not necessarily violent offences. And when you're looking at the trend of prosecuting here, often you find that coercive control is on an indictment or on a charge sheet, but also accompanied by violence, and maybe by sexual violence, but indeed it is, of course, an offence on its own. Gaslighting, and that very much, the circumstances, that framework is particular to the individual woman, usually a woman. The Court of Appeal, the Criminal Court of Appeal, has considered a number of recent authorities, and I've just got the references there really to signpost them to you. A couple of examples that I draw your attention to is the case of Harris, which was a sentence appeal for a woman who was convicted of manslaughter. She actually didn't seek to use the partial defences of loss of control or diminished responsibility in that case. She asserted that she was acting in self-defence. But interestingly, when the court came to look at her sentence, they were very much alive to, in the sentencing remarks, the disparity in age between the parties and the unequalness of their relationships. This was a very young girl, and there'd been a history of violent incidents and history of some controlling behaviour, but very much it was particular to her facts, but that the court recognised that there were those sorts of elements at play and reduced the sentence accordingly. There's also the case of Thomas, which I think is also an interesting case to look at, when and Thomas was a man who was being sentenced for incidents of violence against an intimate partner. And when the court was considering the appropriate sentence there, the court looked at his history of behaviour towards former partners There were incidences of strangulation and other features of controlling behaviour, which meant that the court considered that he met the statutory criteria for dangerousness and extended his sentence accordingly. So the Court of Appeal certainly is alive to some of the arguments, some of the features of this sort of behaviour at that level of jurisprudence. So if we just go over to the next slide, please. Just emphasising again what Claire had to say before, that really the main thing that we would seek to say in our criminal practitioners part of this talk, but I'm sure is applicable across the board, is how important it is to take a full history. There's no real shortcut to that. It requires time and patience. It requires listening more than talking. But it's absolutely crucial to build a case for your lay client. And certainly a appellate case that I have at the moment, when we actually sat down with our client, some of the things she told us that she just hadn't been heard, hadn't been listened to, and the impact on her trial was devastating. So really, really significant to take that full history. And that brings me really on to the next slide, which is effectively an evidential and disclosure checklist. There's quite a lot of features there, but I'm just trying to put the main parts that I consider we ought to look at. If you've got a young client, all of us use social media, but particularly teenagers, you might find that you've got messages, Snapchat, harassment in that way. You might find that you've got some elements of sexual control, pornography use and the like. So looking at those features are significant when you're building a case. And then you can see obviously text messages, listening to 999 tapes, which give a real flavour of actually what is happening in that moment. And just over to the next slide, please, Amy. Thank you. Body-worn footage, really important. The police now have cameras when they attend scenes. They're always recording, and often you can see by body language or behaviour or comments that can be very revealing. Evidence around a household, medical records, witnesses, diaries that are kept and the like, evidence of isolation. So those are features there, and I think there's just one final slide on that, which again gives you other features there. History on bail, being granted indefinite leave to remain, factors that have enabled a person to seek to obtain legal aid in family proceedings, family proceedings that may have been used or abused to facilitate contact arrangements and the like. So being alive to all of those things. And just the next slide, please. Thank you, Amy. And then trial considerations, really, from our point of view. We, in criminal work, understand that there is no typical victim. It's very much something that we understand in respect of sexual violence. And in fact, juries are directed by the judge about that, that they shouldn't expect someone to behave a certain way. And somebody who is a victim may present as detached, may present as angry, may be highly vulnerable, but not present as such. So those are features that we need to be alive to explain, to tell that person's story. And also that there are ideas that, well, you're in a relationship with that person, you went back to them, you've carried that on, and really trying to explain that. And that really brings me on to what Claire also was saying about obtaining expertise to bring into the courtroom to assist a jury with their understanding. But not only psychological and psychiatric assessments, which are key, particularly when we're looking at the partial defences but also expert evidence about what domestic abuse really means for an individual, cultural reports about shame, about not being able to say it, to reveal things until it got much worse. And looking at special measures, looking at the way that you can support your client in the courtroom. They are limited in use, but they can be used. Claire's already mentioned about the partial defences to murder of diminished responsibility and loss of control. There is, of course, self-defence, which is a complete defence to murder and to offences of violence. The problem with self-defence is often it relies upon an immediate threat rather than this culmination of behaviour and the psychological damage that does. So, but it can be used. It was used in the case that I've just highlighted in the Court of Appeal of Harris. So if we just turn over to the next page, please, on the slides. The case of duress, the defence of duress, again, is a complete defence. It's a very high hurdle to mount. It relies upon a high degree of physical duress or harm that might be anticipated. It also relies upon immediacy of what is happening. And it is difficult to mount when you're in a relationship with somebody. But the case of Branford is quite a useful one, just to have a look at that in your own time, which deals with the fact that it is not necessarily irreconcilable that a relationship between two people would cause a person to act in the circumstances which would amount to duress. So in that case, that it wasn't available. That was a case associated with supplying drugs. But in the right case, the Court of Appeal haven't closed the door to duress. So something to reflect upon and to be creative about. And certainly a lot of the cases that I deal with, I've got young women who are left holding the firearm in their home with their children. And these are potentially things which we need to bring to the court's attention. In the right case as well, of course, all of this sorts of evidence might play a role in you acting for your client to make representations that they shouldn't prosecute them because it wouldn't be in the interests of justice or in the public interest. So just finally, I think I've got one more slide. Thank you very much. This is a case called Reynolds, which again is something that if you aren't able to use this background in your trial, this mitigation is very significant, and again, all is not lost, even if it's very, very important. And this was a case where this young woman was taking goods into a prison for her partner, and as you can see, the court decided, having heard more about their relationship and her vulnerabilities, that they were able to suspend her sentence of imprisonment. Thank you very much. Thank you.
Okay, great. Thanks so much, Stella and Claire, for that discussion. So I'm now going to hand over to David Challen, and I'm really thrilled that David Challen has been able to join us this evening. David Challen is a domestic abuse campaigner, and he successfully campaigned to free Sally Challen in a land bank appeal that has obviously already been discussed today. But even though Sally is now thankfully free, David continues to speak out against violence against women, coercive control, and seeks to make women's experiences better recognised within the criminal justice system. So, David, over to you.
Great. So, thank you for inviting me. It's wonderful to hear so many people are discussing this. Obviously, it's very close to me, and why I keep talking about it is because very much we would have wanted someone ahead of us to kind of raise the flag, so to speak. So, and as my mum said when she was released, there's a lot more women in prison who are experiencing this, who have been wrongly tried for murder or other crimes, joint enterprise, or in prison due to coercion control. But really what I'm talking about is where we are now in terms of the domestic abuse bill, which everyone's been waiting a long time for and has been delayed so much. But I think what we've all wanted is something that was right in the end rather than rushing. and so it brings a more holistic approach to tackling domestic abuse. I think there's been a lot of strides since 2015 as laws has come in. We have more awareness coming about now in terms of economic abuse becoming part of the new definition of domestic abuse, and I think that's so vital to have that there. There's a new charity, Surviving Economic Abuse, which was founded in 2017, who are doing amazing, brilliant work in raising that awareness for the, how perpetrators financially control you and your economy. And to an extent, that's what my father did to my mother. And it all plays a role in the cog in what is coercive control, which is a massively complicated idea to get across to someone who isn't aware of it, which is why it's such an uphill struggle, I guess, to raise awareness. I always hear about charities talking about working with victims, and they're trying to understand the tick box, what is coercive control? Is this enough? Is this enough? And very much it is a bespoke, as we've discussed, form of domestic abuse, which really edges away at that person's sanity. And in my mother's case, there was a loss of control. And you're eroding away a person's personality, who then envelops themselves in the personality of the abuser, or cares about that abuser to such an extent they can't separate their own personality. They're so enwrapped in that person. And very much an idea Surviving Economic Abuse is trying to raise with the Domestic Abuse Bill, is trying to make an amendment to incorporate post-separation abuse as well, because very much coercive control is not just within a relationship, it is also after a relationship. And in my mother's case, she did separate, and one of the problems was when my mother reached out to him, there was that acknowledgement of weakness immediately. And so when my father sent a post-nuptial agreement across, that's abuse, of course. That's what needs to be included in the language, so that there isn't a gap there. It's really providing that, like I said, a holistic approach to tackling it, because coercive control is massive, and the reports are doubling year on year. From March 2018 to 2019, reports doubled, and I'm sure they'll double every year as there's a learning curve for the police forces, the judiciary, and the victims to become aware of what it is and seek help. But still, it's tip of the iceberg in the amount of reports of domestic abuse that do come through. For my personal opinion, if there's a case of domestic abuse or physical assault, it would be quite surprising if there weren't instances of coercive control in the first place. And I guess that's the uphill struggle of investigating it. That breadth of information that police forces need to gather to present, and then to be referred to the CPS and then prosecute. And I think that's it's a big problem to have victims that are on the stand, like my mother. If it was post 2015 when coercive control was a crime, would that person be able to acknowledge what happened to them was a crime and was abusive? So it's very much what I guess your clients or victims of domestic abuse are able to impart in that knowledge of abuse, for which to present in a trial that is completely relevant to their experiences, or which they're being reviewed upon. I visited my mother for 8 years in prison. So many women are obviously in prison for crimes, and coercive control is rooted in that, and domestic abuse, and women who are there. And it's about raising awareness. And in terms of how we touched on earlier, Coronation Street and the Yasmin storyline are such pivotal moments to push it forward in bringing coercive control into the subconscious of a nation without being so preachy as into bringing in another term and making it almost a political stance. It's really updating our awareness of what domestic abuse is. It's the ultimate foundation for which to broaden and understand the scale of male violence or domestic abuse, for us to really acknowledge that. And I think we're seeing a massive problem in obviously the family courts. Ever since I started speaking out and going to conferences and speaking to victims, and amazing victims like Rachel Williams, who's an incredible Welsh domestic abuse campaign, you should all check out some of her petitions. You see some of the worst stories of parental alienation, coercive control existing there, and the awareness and the education that needs to take place is still very much an important task, as well as the domestic abuse bill, which is a whole bundle of promises, but has to have funding behind it and has to have education behind it for which to progress and move forward, because very much presenting these ideas in the court of law seems to be quite complicated. Transmitting an idea of, we're talking about a defence to murder, an immediate threat to life. I think that's it's quite an uphill battle to kind of understand coercive control, present in the court of law, and then get to that moment to kind of show that, in my personal opinion, my mother, life was under threat because her sanity was under threat, and she hit out at the spectre of her abuser, which was my father. And I think that's what you need to kind of get across. But for that, you're going to need a jury that is far very developed in their understanding of coercive control, and it's very much the work I try to do where I can. And it's been 5 years since it's a law, but it seems to be one of these things that's slowly going to drip into the consciousness of the public. Someone was saying earlier, I can't remember who it was, artist was saying something about BBC Three documentary about getting young people in a room and watching a drama unfold in multiple parts of a coercively controlled relationship. They did it a few years ago on BBC Three for sexual assault. And it really does help breaks down in parts to kind of question it from each side. Although it is very complicated when we look at these instances by themselves, you can really understand it and envelop yourself in that person's experiences. And very much my mother's one, it all came to very clear when you piece together people's statements, friends, family of both sides of my family throughout a whole period of time. Once you collate them, I think when I first read the original bundle from the original court case, it was a plethora of stories that all lined up to one another. And then when you had a term of coercive control, it really gives you that language of what was happening and what the abusive behaviour was that eroded someone's mind after that time. And it's just basically picking that up in the judiciary. Many victims will either kill themselves, kill their abuser, or just exist into elder stages of elder abuse, which I don't like the term elder abuse, but there will be a lot of older people who are trapped in abusive relationships out of coercive control, and you're having to erode a further traditionalized our mindset of what an abusive relationship is. So I think there's a lot to be done, there's a lot to be achieved, but I would imagine referrals will keep going up, hopefully. I know the reports are doubling, seemingly every year at the moment for coercive control, and very much other nations are considering it, like Australia, although they're a bit more worrisome about that educational leap of, if we're already not doing a good job on domestic abuse, how are we going to educate a public and the police force with an understanding of coercive control? Unfortunately, it's just a necessity. It's such an uphill struggle, but it just needs to be really drummed into people. Although it's not in the consciousness, you've really got to speed it up with the law enforcement, how they investigate and gather that evidence. Because I can imagine it's just so hard to gather that evidence, especially if you have a victim that isn't able to self-diagnose what has been abusive to them. But hopefully, as time goes on, all CCTV cameras, people who are more aware, able to kind of collate that information, log it, and present that as a character reference to what they've been spotting as time goes on. So I hope our case can really be, it has obviously raised significant awareness, although it may not have got to a retrial to kind of challenging it to the full extent. I think acknowledging in the sentencing at the end, the domestic abuse and the loss of control. It's the steps we need to take moving forward to piece these together and come out of a case to really find the links and put the cause of these crimes down to coercive controlling behaviour. Obviously someone has to serve a sentence, has to be the right sentence. We have to learn from that. Has to be the right cause of the crime to really learn, as well as put someone away in prison. And very much when trying to free my mother, as well as recognising the coercive control that she suffered for the life that my father lost, and also the life that my mother lost throughout the entirety of our adulthood. But yeah, thank you. I don't know much more to add to that.
Thank you, David. Thank you for coming to us and for the work that you are doing at the moment, following such incredibly difficult circumstances for you and your family. I'm in a moment going to hand over to back to Claire and to Artis Kagonge and Naomi Wiseman, just to look at the victim's experience of the legal process. Artis is one of the most knowledgeable and measured family law practitioners I know. She left us for a while to work with local authorities as a senior childcare advocate and was very high rated in that role. Unfortunately, she did return to us with that extremely valuable experience. Naomi is very much a rising star in numbers of areas of family law, very highly regarded, and also involved in very much broader issues and simply just case by case, such as child marriage, such as FGM. So I'll hand over to you now for your session.
Well, we thought we would explore the victim's experience of the legal process through some key questions which we're going to discuss. The first question is, what are some of the challenges that victims in the family and criminal justice system face in making allegations of coercive control? I just wonder whether Naomi and Claire would like to comment.
Well, I'm very happy to jump in from the family perspective. I think in very broad terms, any of us that work on domestic abuse cases are aware that there are quite significant issues around minimising domestic violence and domestic abuse, and also to having it marginalised within our cases. It becomes a strategy, it's the go-to defence to say that allegations are fabricated or that they are being exaggerated for the purpose of preventing a perpetrator from access to children, for example. And so we already know that the family court's very poorly equipped to deal with anything beyond the most straightforward of domestic abuse allegations. And I think there's real parallels with what Stella and Claire have been talking about here, which is, I think the same is true in the criminal jurisdiction. Unless you have your sort of headline incident, the punch to the face, or something that is a kind of catalyst for why these allegations are being raised, then the family court has a real tendency to be quite dismissive unless your allegations are pleaded very expertly from the outset. And I think this is again where we can really learn from what criminal practitioners have said about how you prepare your cases, which is if you have a victim who has been subjected to cumulative coercive controlling behaviours over several years of a relationship, then that can't be pleaded properly in 5 allegations in a Scott schedule. And I know, Stella, you said that actually in the criminal jurisdiction, we don't really do schedules. Well, we do allegedly do them in the family jurisdiction, and we're supposed to be a lot better at them. But actually, what you'll increasingly find is where you're trying to plead issues of coercion within private law family proceedings in particular, the current format of our Scott schedules and the approach of judges is entirely at odds with actually effectively advocating for the victim. And by that, I mean you're often restricted to 5 to 7 allegations by a judge. What they often request is that it's a specific incident on a specific date. None of that works when you're trying to plead allegations of coercive control. And the difficulty is the stakes couldn't be higher, because if you don't plead the case properly, what we're tending to find is perpetrators get their defence in first. This is alienation. This is trying to prevent me from seeing my children. And that becomes the dominant narrative of your proceedings if you're not careful. So something that Artis and I have been discussing, and I've discussed it with other practitioners as well, is whether or not when we're looking at our Scott schedules, we should actually try to mirror public law proceedings more, where you would have a threshold document. And actually how threshold documents are dealt with is you have the headline of the effect of the abuse. Is it psychological abuse? Is it emotional abuse? What the consequence of it is. And then you provide the evidence of it rather than the other way around. And I think it's quite an interesting way of trying to reframe how you look at cumulative abuse like coercive control. And so that's one example. I'm seeing a shift in how you can actually develop Scott schedules to look more like a threshold document. But you've still got the sort of hurdle of persuading a judge why it is that you're reframing the allegations in the way that you are, and why you may evidentially need, as has already been set out, I think, again, by the criminal practitioners, a huge amount potentially of evidence. WhatsApp messages, text messages, all those sorts of things are, again, something which judges in the family jurisdiction are very prone to dismiss. Why is this relevant? Why am I having to look through hundreds of text messages? And really that comes down to judicial training and judicial understanding of this form of abuse. Some judges have got it. I would say a lot of judges still haven't got it. And that's all part of the process that we have to work within when you're trying to help someone who has been a victim, and where their case has to be pleaded properly. So I don't know if that's probably as much as I can say on that.
Yeah, I mean, I'd certainly, I did obviously I don't know family law, but I'd certainly endorse that. And I think that one of the sort of biggest challenges for women who are charged with criminal offending, who've been victims of coercive control, is being able to give their account and go into the history of that. And I think there's a temptation quite often, Stella's touched on this in terms of the importance of taking a history, but I think there's quite often a temptation not to take the full history, not to realise that things which may, as I've said, have no temporal nexus to the offence in issue. There's a temptation to think that they're not relevant or for them to be missed. And, in several cases I've been involved in, they've been missed. So, and their forensic significance just hasn't been picked up on. So I think the most important thing is, given that coercive control entails looking at a pattern and not looking at events individually, is to be able to enable women to give their accounts. And often the system is rushed. They don't have legal advisors that they feel able to speak to, particularly about some of the things that they may be traumatized about. There's a history of sexual violence, for example. So I think that's one of the big problems.
Next question is just how we should approach client care and case management in coercive control cases to support victims. And I know certainly from my experience of family law, the first thing we have to do is pause and remember that our clients are highly vulnerable. They're likely to have been impacted in terms of their self-esteem. They may be suffering poor mental health when they come to us with their cases. And our client care skills have got to be at their best. And as Claire said, that overall, it can feel like a very rushed process. And we need to take the time to take that full history and detailed instructions. And that means trying to create an environment or conditions that are most conducive to that. So it's a real wake-up call to practitioners that we need to ensure that we are available and able to have a number of conferences, take that history over a few sessions where our clients can build rapport with us, can feel more comfortable in disclosing the history of their abuse. It's important when you're working and instructing counsel to make sure you arrange that conference days before the hearings. You don't want to be under the pressure of being at the door of court trying to get that type of history. And we also, as practitioners, need to sit back and digest what our clients have told us. Because as my colleagues have said, we're looking for the patterns of behavior, the cumulative effect. And until we sit back and analyze the facts and pick out those patterns, we're unable to give that persuasive account to the court on behalf of our clients. So it's number one, taking that extra time. The other thing that is important, I find, is managing clients' expectations, because as Naomi mentioned, the court can, to an outsider, take a very mercenary approach and limit the allegations to 5. It can seem very arbitrary to clients who feel that their allegations are just being dismissed. And then you, as their legal representative, are then telling them, well, we've got to take the 5 that we feel most able to prove on the evidence. And again, you're reducing and dismissing some of their story. And we have to explain to them that the outcomes are variable, depending very much on the tribunal. And I can see some of you in the chat room talk about that there seems to be a real need for training amongst the judiciary on coercive control. And it's that balance between trying to get a judge to understand it's a pattern of behavior, not just bad behavior, where they might dismiss that as some conflict between 2 parties. So it's really managing their expectations that, it's not that you're disbelieved, but trying to discharge that burden of proof. It can be challenging on the evidence. And in cases where we know it is really one person's word against the other in most cases. So managing those expectations. And I would say finally, in terms of supporting them, in terms of case management, the number of times we fail because of pressures in terms of court listings to say, look, if we're going for fact finding or a trial, let's make sure we have a pre-trial review, because that's an important opportunity for the court to consider special measures for our clients, making those applications. How are they going to give their evidence in a way that's going to be conducive to them telling their best account, and making those bookings with the court office for separate waiting rooms. Those are highly important matters to support our clients. And also being brave to ask for more time or an adjournment when our client comes to court and perhaps overwhelmed by seeing their abuser or just the enormity of the situation, is unable to give coherent instructions, or the judge is rushing you trying to deal with case management issues because it's difficult to get more listings, and saying to the judge, I need time, or saying to the judge, there needs to be an adjournment and an opportunity for my client to address this in written evidence, because essentially she or he just simply cannot be rushed, and I've got to take proper instructions from them. And it's you really standing up and reminding the judge or the tribunal about your client's Article 6 rights, if anything. So I just use that as some examples. I don't know whether my colleagues have anything to add.
Well, I think in terms of how, oh, sorry, Claire, you go.
No, also I was going to say, I think what you say and what Artis has said in relation to family proceedings applies equally in relation to criminal proceedings. I mean, these are factors which are readily translatable between the jurisdictions. Sorry, I cut across to you, Naomi, so I don't know.
No, not at all. It's something that's being discussed as well, which is the family court has to become more trauma-led. And part of that is about understanding how a victim's trauma can manifest itself. And specifically within court proceedings, that could mean changing their mind a lot, agreeing to one thing and then seemingly pulling back and rowing back from it, changing their instructions. All these things that we as practitioners would say, that makes my job very difficult. And you have to take a step back and say, this is not about my job being difficult. This is about actually trying to understand why my client might be behaving in a way that on one level looks as if it's deliberately trying to frustrate these proceedings, but actually it's just a result of the trauma that they have suffered. And getting the court to understand that, getting your opponent to understand that. And there's often a real absence of an ability to get the sort of expert evidence that, again, Claire and Stella were talking about within criminal proceedings, and increasingly we're trying to get a support worker from Refuge, those sorts of people who have worked with your client, to put in letters and statements about their experience, because often that's all you have to rely on if you can't have, a psychiatric or psychological assessment of your client that can actually determine this person has suffered trauma and that can manifest itself in these different ways. We have to move to an approach where if a victim is saying they have been subjected to certain behaviours, then the presumption should be that they may be therefore affected in certain ways. Not that you have to go off and get some elaborate expert report to actually prove that they suffer from these things, because that causes huge amounts of delay. And I think that's something we really have to be mindful of in family proceedings, is trying to move to a place where actually the presumption is that the process is trauma-led, not that the victim has to prove their trauma in order to even have their behaviour understood. So I think that is something we as practitioners need to be mindful of and advocating for.
I'm mindful. I want our co-chairs to open it up to the audience questions and answers. But one thing that's been on the mind of everyone is how is COVID-19 impacting victims of coercive control? And I think this can open up generally to the panel. I think the obvious answer is delay, and that means delay in getting your case heard and really having the proceedings hanging over for a lot longer. I'm finding in the family court, particularly in private children matters, I'm averaging 5 months between hearings at the moment. And I don't know whether my colleagues have had similar, but really just unprecedented delays is taking its toll on our clients in these cases.
Thank you for that, Artis. We are beginning to run out of time, I'm afraid. There are numbers of questions in the Q&A box, and I'll try and deal with a few of them now. But I think we've tried to go across a huge range of stuff this evening. This is from an anonymous attendee who says, I found whenever I've supported a survivor of domestic abuse through the courts regarding coercive control, practice direction PDJ 12 is all but ignored. The judge may agree that there was abuse towards mum, but not the children. Would the panel say that they have found this to be the case, and is it improving? I don't know whether Artis or Naomi can comment on that.
I think it is improving, the sense that, I think when I first started in practice, it very much seemed to be the case that, well, if mum's been subjected to this abuse, what does it matter? And we can put protections in place for the children, be that forms of supervision, or work for the father to undertake before contact can move to be unsupervised. I think increasingly, because I think of the exposure around this idea of more subtle forms of abuse, it is now starting to be understood that the perpetrator can transfer the abusive behaviours from partner to children, and that often what that can be very re-triggering for a mother, because what she sees happening are her children being abused in the way that she was. So I don't think it is improving across the board, but I do think it's something that judges are now more aware of and less dismissive of, which is why I think we're increasingly seeing fact findings in family proceedings being ordered, where I would say 5 or 6 years ago, you may have just seen that completely dismissed. Let's just try and move on with the contact. Let's try and get father seeing the children, and we can just park these abuse allegations because they're not really relevant. So, I mean, I don't know if the other family practitioners want to chip in, but I do think that is slightly improving.
Can I just say to that, I think the points that have been made about there needing to be training for the judiciary is absolutely vital, be it the judiciary or, in fact, of course, lay magistrates who hear quite a lot of these cases in the family courts. And, of course, there is the problem, and I know it's even bigger problem in the criminal courts, of court time available. I was thinking about when I did this case the last 2 weeks in front of Mr. Justice Hayden. It's all very well for the High Court to have 2 weeks of court time available. That's just not available in the lower courts. Can I just move on because of our time constraints? A question from Bridget, I think for David, and it follows on. Can I ask, what is a child's experience of this when growing up in a household where this is happening by a parent to another parent? And that's quite often, it has a great relevance in family proceedings, David, as well as criminal proceedings.
Yeah, I think it's very nuanced. I think I didn't really spot something was wrong until maybe 16 or 17. At that stage, I think your parents become a bit more open to their own lives, and the veil, whatever veil was there, starts to come down. That was very much the route of my father. In terms of seeing it, you would just notice subtle, just in arguments, it was just plain old gaslighting. My mother would print off phone records, trying to prove that he's calling a certain person, where it's made out in court that she's stalking him. It's really a person finding their own reality for which to leave that person. But really, he's saying, "You're going mad, Sally, you're going mad." Kind of mantras like that would just ingrain within her. And she later said, when she did prove me right, that I thought I was going mad. Look at these things. I'm just, it's all in my head. I think really that nuance of the kind of drip of kind of seeing it is very much the same for a child, and especially at the time when there's no language of coercive control. It was that was the only point that I saw it as abusive, but there's nothing for me to call it abusive. But it's the small put downs here and there all the time, and dinner being ready on the table. The archetypal traditionalist kind of roles in society, which are in fact actual controlling and coercive, and that someone clearly doesn't want to go along with, but that's your conception of what a normal family life is like. So I think it's quite as hard to get it out of children as it is the victim, not to sound really pessimistic, but truthfully it's you have your own experiences to reference what is a normal family life, and it takes a lot of turmoil to kind of make you think otherwise until you see another person's family.
And somebody else has actually brought up the question of whether in some of these cases that to what extent could evidence from the children be used? Do you do any...
Shall I answer that?
Yes, please, David. Yes.
Well, certainly from everything could be different from the original trial, practically in every kind of possible way, even if coercive control's around. But it's of course it's character statements. Unfortunately, did my victim impact statement with a family liaison officer looking over my shoulder whilst I was with my brother, and I felt like I couldn't confer with him. I think, it's I would like to say it's a very nuanced kind of circumstance, but I know that it isn't, because obviously there's lots of other women in prison for the same circumstances. But I think the way in that scenario that I was treated was very much like the wolves are in the room with you, and their family liaison officers. And I know they do great work, but certainly they just look like wolves to me. And I felt that impacted what I could put on paper in terms of whatever victim statement that I could put across. Not that, I mean, is this worth saying? I don't know. I know when I got up on the stands, I think there was a lot more that all of us wanted to say, but we didn't know if we could just answer beyond what were the straightforward questions at the time by the barrister in the original trial. So very much looking back on my experiences, I would certainly hope not to end up in that scenario, anyone else to end up in that scenario, even with coercive control as a defence, to be able to kind of speak your mind and broaden from what are the questions that you're being asked. It's not asking to be coached or anything, but I just like to know that I can go. It's a very, walk into a court. It's a boiler. So you walk into like a steam room, like a steam pot. It's the pressure cooker. So I've very much. There's a lot you can get from children, just asking them just to explain it out, just as much as you would from a victim, and then you can kind of hear the nuances of abuse.
Thank you, David. I'm just going to take one more question now, I think, before we wind up. This is from Alice, who says, I work with women who are often victims of coercive control, and the overwhelming feedback is that they feel hopeless. Police and social workers aren't interested in this type of abuse. They feel that the perpetrators move on with their lives without any consequences from their actions. Don't know whether anybody can comment on that as something that they have also experienced. Certainly.
Sorry.
Go on, Claire. Yes, go on.
Yeah. I was just going to say, I think that one of the problems is that there just aren't sufficient resources, and there isn't sufficient understanding of the way in which coercive control operates for victims to feel that they can escape. And that's the problem. I noticed there was another question here, which is how do we stop this sort of abuse from happening and stop a particular situation getting to the state where somebody feels that they have no way out, literally no way out, and that their survival is in the balance, and that they have to kill in order to escape such an intolerable situation. And I think the difficulty is there still isn't enough understanding. So we've spoken about police officers, we've spoken about looking at evidence, of course, from previous incidents, from crime reports and so forth. But back in 2014, the consultation paper that was prepared in advance of the 2015 Act being enacted referred to a quotation, I think, from an inspection by Her Majesty's Inspector of Constabulary, saying that many police officers still didn't understand domestic abuse that they saw as being non-violent. There just isn't that understanding there, and that's why victims feel so hopeless. And it doesn't surprise me that they feel hopeless. There just aren't the resources, and the importance. I think the most important thing about coercive control is it focuses on the lack of resources. It focuses on the erosion of of self-identity, of personhood, and so forth. And unless you provide the resources, victims will just continue to feel hopeless, and they will continue to feel that they can't escape a situation.
Thank you. Claire. I think at that point, I think we're probably going to need to wind this up. We've gone over our time. It is incredibly helpful to hear from people involved in the criminal justice and in the family justice system. And particularly, I thank David very, very much for coming along. Extraordinarily helpful. It's such a wide area, it's such a huge area that I suspect that we're going to have a follow-up webinar to this to deal with different aspects of it. And we've got all the questions that we've not been able to deal with. So I certainly am going to have a look through those with other people. I've been asked to pass on thanks to Kate Ryan from IBB for her input. And I would like to thank you all for coming very much. Rachel, is there anything you would like to add?
Yes, just incredibly quickly, as obviously we are wrapping up, sorry. So can you see the slide here? It's just about the impact of COVID-19. I just wanted to signpost everyone to Women's Aid recent report called A Perfect Storm, the impact of the COVID-19 pandemic on domestic abuse survivors, which is an extremely interesting report looking at the impact of the first lockdown on domestic abuse survivors. And as you can imagine, the lockdown has not been at all good for victims of domestic abuse who have been stuck at home with their perpetrators. And the final slide is just signposting to some various agencies that can help if you or anyone you know is experiencing domestic abuse or coercive control. And I believe these slides will be shared afterwards. So I hope that this might be able to help someone who needs it. So I suppose all that's left to say is thank everyone for coming. It's been such an amazing opportunity to hear from all our panelists, and I hope everyone has a good rest of their evening. Thank you.